The International Building Code Section 2,003,105.2.3 addresses public service agencies and states that a permit shall not be required for the installation, alteration, or repair of generation, transmission, distribution, or metering, or other related equipment that is under the ownership and control of public service agencies by established rights. The Pennsylvania Uniform Construction Code Section 403.62, subsection E, provides a similar exemption. A permit is not required for the installation, alteration, or repair of generation, transmission, distribution, metering, or other related equipment that is, by established right, under the ownership and control of a public utility, as the term public utility is defined in Title 66 of the Pennsylvania Consolidated Statutes, Section 102, relating to definitions. The National Electrical Code 2002 edition, Section 90.2, Scope, subsection B, not covered, Item 5, clarifies what the code does not cover. Specifically, it excludes installations under the exclusive control of an electric utility where such installations firstly consist of service drops or service laterals and associated metering, or secondly are located in legally established easements, rights of way, or by other agreements either designated by or recognized by public service commissions, utility commissions, or other regulatory agencies having jurisdiction for such installations, or thirdly, are on property owned or leased by the electric utility for the purpose of communications, metering, generation, control, transformation, transmission, or distribution of electric energy. Now, let's consider a scenario where a contractor installed a 200 amp service for a phone company's Mesa cabinet. The phone company argues that this installation is under their control and therefore exempt from requiring a permit. The state administrator for the Department of Labor and Industry agrees with the phone company's position, citing the language provided in Section 403.62 of the Pennsylvania Uniform Construction Code. Understanding the exemptions described within these codes requires careful consideration of several factors. These factors include the nature of the entity performing the work, the type of work being performed, and the location of the work. The International Building Code and the Pennsylvania Uniform Construction Code both provide exemptions for public service agencies and public utilities, respectively, for equipment they own and control. The National Electrical Code provides exemptions for installations under the exclusive control of an electric utility, including service drops or laterals, metering equipment, installations located in easements or rights of way, and installations on property owned or leased by the utility for energy-related purposes. Based on the reference codes and the described scenario, the phone company's argument appears to be valid. The 200 amp service installed for the Mesa cabinet may indeed be exempt from permit requirements under certain conditions. Firstly, if the phone company is classified as a public utility under the relevant definitions, and secondly, if the service is under their exclusive control, and thirdly, if the cabinet is located on property owned or leased by the phone company for the purpose of electrical distribution, then the contractor who installed the service would not be required to obtain a permit. It is important to note that the specific definitions of terms like public utility and exclusive control may vary depending on the jurisdiction. These definitions should be carefully reviewed to determine whether they apply to the specific circumstances of the project. Additionally, it is important to consult with local authorities and permitting agencies to confirm whether an exemption applies in a particular situation. They can provide guidance on the interpretation of the relevant codes and regulations. Now, let us break down the requirements for these exemptions. For the International Building Code, the key is ownership and control by a public service agency. This means the agency must both own the equipment in question and have the authority to manage and operate it. For the Pennsylvania Uniform Construction Code, the same principle applies, but the entity must qualify as a public utility as defined by Pennsylvania law. This definition may include entities beyond traditional electric or gas companies, depending on their regulatory status. The National Electrical Code focuses on the level of control exercised by the electric utility. Exclusive control means the utility has the sole authority to operate and maintain the electrical infrastructure. This typically applies to service drops, laterals, and equipment located on utility-owned property. The location of the equipment is another critical factor. Easements and rights-of-way grant the utility specific legal permission to install and maintain equipment on land that is not directly owned by them. However, these agreements must be legally established and recognized by relevant regulatory agencies. To summarize, the 200 amp service installation may be exempt if firstly, the phone company meets the definition of a public utility in Pennsylvania, secondly, the service is solely controlled by the phone company, and thirdly, the Mesa cabinet is located on property owned or leased by the phone company and used for electrical distribution. It is essential to remember that these exemptions are not automatic. Phone company must be able to demonstrate that they meet all of the required conditions. This may involve providing documentation to the local permitting agency, such as proof of ownership, easements, or regulatory approvals. It is also important to note that even if a permit is not required, the work must still be performed in accordance with all applicable codes and standards. This includes the National Electrical Code and any other relevant local regulations. The purpose of these codes is to ensure the safety and reliability of electrical installations, regardless of whether a permit is required. Furthermore, it is crucial for contractors to understand the scope of these exemptions. They should not assume that all work performed for a utility is automatically exempt from permit requirement. Instead, they should carefully review the relevant codes and consult with the utility and local permitting agency to determine whether an exemption applies in each specific case. Failing to obtain a required permit can result in fines, penalties, and delays. It can also create liability issues in the event of an accident or failure. In addition to the codes mentioned earlier, there may be other local ordinances or regulations that affect permit requirements for electrical work. These local regulations can vary significantly from one jurisdiction to another, so it is important to be aware of the specific requirements in the area where the work is being performed. For example, some local jurisdictions may require permits for certain types of electrical work regardless of whether the entity performing the work is a public utility. Other jurisdictions may have stricter requirements for inspections or documentation. To ensure compliance, contractors should always check with the local permitting agency before starting any electrical work. They should also document all communications with the utility and the permitting agency, including any agreements or understandings regarding permit requirements. This documentation can be helpful in resolving any disputes or misunderstandings that may arise later. In conclusion, understanding the permit exemptions for electrical work performed by public utilities requires careful consideration of several factors, including the relevant codes, the definitions of key terms, the location of the work, and any applicable local regulations. Contractors should always consult with the utility and the local permitting agency to determine whether an exemption applies in a specific case. By following these steps, contractors can ensure compliance with all applicable requirements and avoid potential problems. Firstly, always confirm the utility status. Is the entity legally classified as a public utility in that jurisdiction? Secondly, verify control. Does the utility have exclusive control over the specific installation? Thirdly, check the location. Is the installation located in a legally established easement, right-of-way, or on property owned or leased by the utility? Fourthly, review local regulations. Are there any local ordinances or regulations that may affect permit requirements? Fifthly, document everything. Keep records of all communications with the utility and the permitting agency, including any agreements or understandings regarding permit requirements. By following these steps, contractors can navigate the complex world of permit exemptions and ensure that their work is performed safely and legally.